The Case of the Fighting Forums. This law video is a learning tool to analyze three forms of dispute resolution: litigation, mediation, and arbitration. What are the strengths and weaknesses of each form of dispute resolution? Litigation is taking a dispute to court, and it has its advantages. It's a traditional way to resolve disputes. You may hire a professional advocate, a lawyer, an attorney to represent you. Oh, and when you go to court for litigation, the rules and procedures are well known in advance. In fact, you can even discover your opponent's evidence prior to going to court. You are not bound. You may appeal the decision to a higher court. Litigation is court resolution. The problem is it takes just too much time to get on the calendar, a year or more, and it's costly. Oh, it's costly. Legal fees could run into the hundreds of thousands of dollars. And with litigation, the loser is not bound and may appeal the decision. There's also litigation in small claims court, and it has its advantages. It's faster to get on the court calendar, 2 months or less. And in small claims court, you may represent yourself. And small claims court, why, it handles disputes up to $10,000. Disadvantages of litigation in small claims court means that, well, you might be facing a professional advocate on the other side, a trained lawyer, a trained attorney. They know what they're doing, and you don't. Jurisdiction in small claims court is limited to where the defendant actually lives. You may have to travel a long distance from your own home to be where the defendant resides. And there's a limited financial jurisdiction. You can only get a dispute resolution up to $10,000. Also in small claims court, the loser is not bound by the decision. If they put down an appeal bond, why, they in fact may appeal the decision to district court.
Welcome to mediation. It is good that you two could meet today. As you know, you have given me permission to record this session. My name is Maxine Median, and I am the mediator for this dispute. You two first selected 3 names from a list of experienced mediators, and then you each had the opportunity to eliminate one of the names. So by default, I am here as your mediator. This is a totally voluntary session. We will talk together now, and then I will meet with you individually before we all meet together again. If there is an agreement, you two will sign it, and I will be the witness. Since the courtroom is next door, we will take the document over to the court and present it to the judge. She will ask if they are your signatures on the document, and if this is a voluntary agreement. Allow me to remind you that you are not required to give up your rights, and you are not bound by the results unless you sign the agreement. You may leave at any time. Now will you please each introduce yourself?
Hello, my name's Trudy Traveler. Months ago, I went in to see Patty Peck about taking a luxury cruise to Europe, and she convinced us that I would love to go on the Queen Mary 3, and I was all excited about going. So I made a deposit, we decided on a date, and after that we began to have some troubles.
I'm Patty Peck. I'm a professional travel agent for over 30 years. I am also a master cruise counselor and have won numerous awards for my cruise experience, knowledge on destinations, and customer service. Our agency is also a member of the prestigious group of travel agents known as Virtuoso.
Thank you. Now the question is, what happened that brought us to this mediation table today?
Months ago, I went to Ms. Peck and paid the majority of the cost to go, $37,000, to go on our cruise, and I was very much looking forward. Since that time, a great deal of trouble has happened in Europe. There have been bombings, explosions, fires, people being killed, and my husband and I decided it was too dangerous to go on this trip.
Did you by chance purchase travel insurance which would have allowed you to change your mind about the trip?
No, we have plenty of insurance. I didn't see any reason to buy any travel insurance.
Okay, so what happened next?
Well, a few days before we were supposed to go on our trip, I tried to contact Miss Paik and tell her that we weren't going on the trip, but she was unavailable. She was out of town. And I texted her, I left many voicemails, but I was unable to reach her. So come Monday, we just didn't go on our trip.
So Trudy came in and we discussed some vacation options for her, and what she chose was a Queen Mary III $37,000 suite on Europe cruise. Went over all of the particulars about the cruise, emphasizing the importance of buying trip insurance. Among the things that it protected her is if their cancellations were made within 96 hours before sailing. The cruise line's rule is cancellations must be received before that time. They offered insurance, had to be purchased with a deposit. Asked her about it. She said she only wanted to do the deposit, which is what I did. A little bit later, I sent her the brochure of the cruise line. I marked the cancellation information on the brochure. I sent her a confirmation letter that went over all the particulars also. And I mentioned at that time, since she had not purchased insurance, that she could still purchase third-party insurance, which I supplied her with this brochure. I told her to let me know if she would like to include it. Didn't hear from her. About 60 days before sailing, it was when she needed to do the final payment. I called her, asked her if it was okay to charge the balance, and she said yes. I said, well, do you want to go ahead and add that insurance that I mentioned? She said, no, we're absolutely going to go on this cruise. Nothing could keep us from doing it. So I followed her rules, called in the full amount that was due. About a month before sailing, I sent her documents, which included in the documents was a notice from the cruise line outlining their cancellation policy again. Never heard from her about anything until I returned from work on Monday, the day she was to sail, and I had a slew of phone calls, emails, text messages that were all started on that Saturday and Sunday saying they had decided they did not want to go on the cruise. And nothing I could do. That ship had sailed.
I wish you'd had someone taking your calls for you. Perhaps they could have helped us or directed us to at least go on anyway, but that didn't happen.
The rules wouldn't be any different if somebody else was there. It didn't matter. You were too late. You didn't buy insurance.
Well, I can see this is getting us nowhere.
Well, you're not.
I would imagine that we will have to take the next step. Please excuse me, I've discussed this all I choose to.
That seems to be the end of our mediation.
I guess so.
Thank you, Mrs. Paik.
Good afternoon. My name is Alan August. I'm a professional arbitrator. Before we begin, do you both agree to be bound by the decision I'll make here today?
I do.
I do.
To confirm that you agree to be bound by the decision to be made here today, I have an arbitration agreement which I need you both to sign. What it says is the decision will be made based on the testimony and evidence you give here today. This is like a court trial, but there is no jury. Do you understand?
Yes, I do.
Okay.
I do.
Well, what brought us to arbitration?
My name's Trudy Traveler. Several months ago, I went to Ms. Paik to purchase a vacation for my husband and I. And she convinced me that I needed to take this $37,000 cruise on the Queen Mary III to Europe. And we were excited about that, couldn't wait. But then all this terrorism broke out, and people kept dying and getting blown up, and fires and all kinds of public places, and we became too afraid. We decided it was too dangerous, too life-threatening to go on this cruise. So I tried to contact Miss Paik to tell her that we couldn't go on the cruise, to find her unavailable. I texted, I left messages on her phone, and it was to no avail. There was no way I could get in touch with her to get help with canceling my cruise.
Do you have any written documentation you tried to contact your agent? Do you have any phone records?
Mr. Arbitrator, I don't have any phone records. I thought my word would be good enough.
Mr. Arbitrator, what she fails to keep bringing to your attention is the very important point that she tried to cancel 48 hours before she was going. It was too late. Cancellation policy was 96. I cannot begin to tell you how many times I've told her that. It was in the cruise line brochure, my confirmation letters, my verbal things. At every opportunity, she refused. She said, we're going on this trip. We don't need this insurance. I explained. She said one time, she said, I already have health insurance. And I explained it wasn't just for health insurance, that it covered a variety of other things. And one of them was cancellations within the last 96 hours. I don't know what else I could have done.
Do you have any written documentation about the cruise and its cancellation policy?
When I got in on Monday, I did get all her messages and text. And here's a copy of the email that I sent to her explaining that it was too late. I copied the policy of the cruise line. She called me again, and I then 4 days later, I guess it was Thursday after, I explained that there was going to be no refund, and if she had any cause of action, she needed to take it against the cruise line. I'm the travel agent.
Do either of you have any further evidence to present?
No.
Well, my thing is, she doesn't understand. I'm the agent of the cruise line. I'm not the one in possession of her money. She needs to be contacting the cruise line directly, not me.
Okay, I've heard all I need to hear. You'll have my decision within 10 days, written decision.
Okay.
Thank you.
Now the decision is up to you. Did the travel agent deliberately leave her business cell phone in her office so that she would not have to have any passengers reach her to cancel during the weekend? Did not having a cell phone really make any difference? Is the traveler entitled to have her $37,000 back? How would you decide? Post your answer in Moodle under the section of forums for the case of the Fighting Forums.